Empty in the middle. Empty in the middle.
Farley has a Harley. Farley has a Harley.
What was going on over there in Fratland? In Fratland.
Empty in the middle. Empty in the middle.
Farley has a Harley. Farley has a Harley.
In Fratland. In Fratland.
Ladies and gentlemen, thank you.
Listen to Pavarotti. Can I be your superhero?
Hello, welcome to The Revealing. I am your host, Pavarotti, and I'm here to discuss the Idaho 4 case. And boy, this case sure is blowing up right now, or it's on the verge of blowing up. Let me just say that. A lot of people are looking at a lot of things, and there's about to be some real talk on real things going on. But I think it's important for us all to know where everybody stands on this stuff. You know, I did a live the other day with Harsh, and we discussed some things like whether or not we felt like Brian Kohberger's defense team was still involved, had a plan, and was that plan sound? I know my guy Harsh believes firmly that no, they don't, and this thing's just going to go away after this little deadline. And then I was listening to A.R. Hayes on there, and he was dead set that no, there is no way. So I like everybody to know that I'm absolutely 1,000% firm in what I believe, and I believe absolutely there's going to be post-conviction relief filed in the case. It's not going to be on ineffective assistance of counsel. I believe it's going to be on newly discovered evidence as it relates to the leak investigation, and there's a lot of reasons why I believe that's the way it's going to go, including a lot of the new stuff that we've heard here over the last week. And I'm going to tell you how all that applies to the situation in this video. I know some people think that Kohberger has already filed. Now, I know as the reporting came out with the Idaho Statesman about trying to get access to the financial breakdown of what the defense team allocated the funds that they used for, and the court actually ordered that, you know, a lot of that information could be unsealed to the public. Well, what happened when the court ordered for that information to be unsealed to the public? Because what it would do is it would actually expose a lot of the defense, even in some cases, their work product. Now, I firmly believe all that is being held back strongly by the defense for trial. So a ruling on, you know, the Idaho Statesman getting access to a lot of that financial information would expose work product that the defense is holding back for trial. So what they did was file for what's called an an appeal that gives them the ability to file an appeal. All right, so they didn't file an appeal. They filed for a motion for the judge to rule, allowing them to actually appeal the decision to the Supreme Court. So the judge has to rule that they can even do the appeal to the Supreme Court. And it's not for the Kohberger filing for his case. It's for the ruling that came in under that judge for unsealing information to the Idaho Statesman. So that is two separate things. And then the state has appointed an appellate attorney to argue that case with the Supreme Court because they were granted the right to file an appeal with that. Totally separate from what we're dealing with here as far as Kohberger's conviction, post-conviction relief appeals with this case. What I'm going to do is try to clarify in this video that right now we are sitting on two deadlines. And I was listening to Kathy the other day, and Kathy's exactly right. Kathy IndyZone, who I have a ton of respect for, she's exactly right. That why you have two windows now, two deadlines, is because one deadline greatly affects the ability to file a habeas corpus petition. And in my research on it in the past, because the post-conviction relief deadline is extended due to Garza, you have to file for post-conviction relief and be denied before you can file a habeas petition. The way I understood it was because you got the extended deadline to file the post-conviction relief, then you would still extend the deadline out for the habeas petition once that was ruled upon. And it works a little bit different. There's a catch-22 in Idaho. The law is really, it's kind of messed up. So while all that does hold true, you have to file prior to the habeas deadline, post-conviction relief, for the habeas deadline to do what's called tolling. If you file before the habeas deadline is up, then whatever time's left on that clock is tolled. So if you were to file, that clock comes up July 23rd. And I'll explain this further in more detail later in the video. But just know this, we've got two deadlines that we're dealing with here. There's 22 days and there's 65 days. If nothing happens in 22 days, Kohberger won't have the right to file a habeas corpus petition once his post-conviction relief is heard. If he waits 65 days and doesn't file anything, this thing's done, in my opinion. So we got some really big stuff happening here over the next 65 days, really over the next 23 days. With all that being said, let me show you why I feel the way I feel. I believe there will be a post-conviction relief filed. I don't know if it's going to be in the 22-day window or the 65-day window. It's not going to be for ineffective assistance of counsel. It's going to be for newly discovered evidence in the case. And what that newly discovered evidence is clear to me. It should be clear to you by the end of this video. Hold on to your hats, folks.
I understand the court might entertain some things in a closed environment later today, and we do have some sensitive.
In the closed session this morning, I indicated to you I am going to be entering an order requiring retention of records by the state, and I'm going to write another one extending that to the defense as it relates to violations of the non-dissemination order. I'm going to give you a copy of what that order is going to look like that I will execute likely over the lunch hour. It does require some action on your part, counsel. And as I indicated, I would be open to a request for a appointment of a special prosecutor, and that special prosecutor to ask for a magistrate inquiry so they have the power of subpoena and the power to question witnesses under oath, as well as the power to grant immunity. So I will be looking for that from you. And that one just deals with the state.
First of all, we got to talk about the word unprecedented. A lot of things in this case have been unprecedented. That means there's no prior legal decision or factual event to serve as an example or a standard. So when people talk about things that they know from their life experiences, especially as it relates to the court system, well, it's not really applicable in this case because of all of the things that are unprecedented, such as the fact that in this case, the news media was so overwhelming with their coverage and so overly biased with their coverage, it led to a successful change of venue in the case. It was moved from Latah County to Boise, Idaho, because the media landscape had poisoned the jury pool to the tune of 90%, believing Kohberger to be guilty before ever even sitting down for voir dire in the court. Then the unprecedented historical leak of evidence that was protected by a non-dissemination order, including video, phone pictures, location data, as well as a lot of things that were not even going to be admissible at trial, leaked to a national news organization who then, 3 weeks before trial, created a documentary and not only presented all of the leaked evidence, but also presented it in a very biased way to take any possible juror out there that hadn't been poisoned already and poison them. Then when the defense files a continuance because of this, they cite that, and they cite upcoming releases that were going to happen between then and the next 3 weeks before they started to see a jury, such as another documentary from Amazon, an actual series where they could only assume more leaked information may appear. Not only that, a book by one of the most popular writers out there, James Patterson, was set to be released before the trial as well, and the defense cited that in the continuance as well. When you couple all of that with the fact that the judge denied the continuance, forced the trial date, and the judge was noticeably upset and claimed to be upset in court, you have to know something isn't right in this unprecedented scenario. Then when people say, why would Kohberger take the plea deal, with everything that I've just said in mind, and the fact that it wasn't just the death penalty he was facing literally the machinator. They were literally in the process of building a special room to not only take his life, but to line up a firing squad and shoot him. It wasn't normal circumstances. In fact, it was unprecedented. And the judge, I think, really shows how he really feels about this leak situation initially in court.
In the closed session this morning, I indicated to you I am going to be entering an order requiring retention of records by the state, and I'm going to write another one extending that to the defense as it relates to violations of the non-dissemination order. I'm going to give you a copy of what that order is going to look like that I will execute likely over the lunch hour. It does require some action on your part, counsel. And as I indicated, I would be open to a request for a appointment of a special prosecutor, and that special prosecutor to ask for a magistrate inquiry so they have the power of subpoena and the power to question witnesses under oath, as well as the power to grant immunity. So I will be looking for that from you. And that one just deals with the state.
So then I take what I know and I just start applying it, right? We had the plea deal in July of 2025. Between then and now, a lot of things have happened. It's June 30th. We have 66 days to go to the deadline on September 3rd, 2026 for the defense or Brian Kohberger himself to file for post-conviction relief. But I think about all that's happened between the plea deal and today, like the fact that the documents in the case have in large part been released. And not only that, the documents that were released show not only no new evidence against Brian Kohberger, but the documents show more exculpatory evidence than we can even count. Law enforcement and the prosecutor, through interviews with news media, literally debunked every mainstream Moron and Gilter talking point that there was. Kohberger bleached his car out. He was seen in Pennsylvania washing his car with bleach. Kohberger was seen putting his trash in his neighbor's trash can. It was all a bunch of lies, and they've already debunked it. And then what was left, such as the car, the CSLI, even the DNA, our community has destroyed what evidence they thought they had against him. There's no reason for him not to file. Then I think of this. We know now, thanks to Brent Turvey going out and running his trap, that all three of Brian Kohberger's defense attorneys are still actively involved in his defense. All three attorneys, including one that is an out-of-state Pro Hoc Vice attorney, is still assigned as active counsel to the Brian Kohberger case. Couple that with the fact that there is no new record on the case summary since April 15th, when they made a ruling on restitution, and no move by the judge to this day to unseal documents since the last time he posted it on December 18, 2025. Nothing has happened. Everything's been frozen. Then we get defense expert Brent Turvey. He comes out and interviews and confirms two things for us that are actually huge. He confirms that, number one, that special prosecutor that Judge Hippler assigned to investigate the leak completed his investigation or her investigation. But not only that, once it was complete, a criminal investigation was started and, as far as we know, is underway or could even be complete. We don't even know. But here's what we have to understand. Because of the criminal investigation that was started after the special prosecutor investigation, what likely happened was the special prosecutor's work was thorough enough, because they had the ability to use those subpoenas, compel testimony, immunity, to develop concrete evidence and strong indications that one or more people violated the court's order, and the circumstances or additional facts surrounding those violations rise to the level of potential criminal conduct. And that justifies involving law enforcement for a full criminal investigation. The special prosecutor could have issued contempt of court or could have recommended contempt of court to be issued by the judge. But the fact that a full criminal investigation is underway due to that investigation all but certifies that they found evidence of the leaker, and it was enough evidence to be possible criminal charges. It's actually a big thing in this case. And here's why. Because when we go back to the original special prosecutor's investigation and what it would produce, you see that investigation would produce documents on its own, such as the original order appointing the special prosecutor and any amendments defining the scope and powers of that special prosecutor by Judge Hippler. Court orders granting any immunity, enforcing or quashing subpoenas, or resolving privilege disputes that the special investigator enforced during the investigation. Any final report, memorandum, or recommendations filed by the special prosecutor with the court, or relevant excerpts or redactions. This is often the single most useful document, as it may summarize findings about who accessed or disclosed specific protected evidence, any violations of the non-dissemination order, or inconsistencies uncovered. He'll also produce documents like subpoena returns or produced records from law enforcement, prosecutors, or court personnel showing access logs, internal communications, emails, memos, text, or chain of custody documentation for specific evidence items that were leaked. These could support claims of mishandling, selective disclosure, or new impeachment material. Forensic metadata or authentication reports comparing the leaked materials to the official protected versions, e.g., timing of access, alterations, discrepancies. Such reports could constitute newly discovered evidence of authenticity issues and prior knowledge not disclosed at trial. Any documents or testimony summaries indicating that information leaked differed from trial evidence or revealed alternative explanations or inconsistencies, material to guilt or sentencing. These will all be documents that investigation should produce. Now, why would that be important? Because everybody talks about ineffective assistance of counsel. When you go to post-conviction relief, which is Idaho Code 194901, to whom available, any person who has been convicted of or sentenced for a crime and who claims that there exists evidence of material facts not previously presented and heard, that requires vacation of the conviction or sentence in the interest of justice. And that, I believe, will be filed under newly discovered evidence or facts. You see, Idaho Code 194901 also allows relief on the ground of newly discovered evidence that was not known at the time of trial or plea, and that could not have been discovered without due diligence. You see, if the leak investigation produces new information, such as the identity of the leaker, evidence that the leaker was a state actor or witness, details about what was improperly released, or information that affects the credibility or availability of state witnesses, this could be presented as newly discovered material. The petitioner would need to show that the evidence was not available earlier, that it is material, and that it would likely have changed the decision to plead or the fairness of the proceedings. We know they could not have obtained the information earlier because the leak investigation had not completed at the time of the plea. And everybody involved would have anticipated this and known this, including the judge, including the state, and including the defense team. 194904. I heard somebody talk about if Kohberger wanted to file post-conviction relief, he'd have to pay for the attorneys themselves, all of the expert, he'd have to pay it all out of his own pocket, which was ridiculous. 194904, Idaho Code, inability to pay costs. Just like during his representation, Kohberger is declared indigent. If the applicant's unable to pay court costs and expenses of representation, including the stenographic, printing, witness fees and expenses and legal services, these costs and expenses, and a court-appointed attorney may be made available to the applicant in the preparation of the application in the trial court and on appeal and paid on order of the district court by the county in which the application is filed. You see, the Latah County would still have to provide Kohberger a post-conviction relief attorney and all the other services that surround that, just like he had before, because Kohberger would be declared indigent. Much like David Meister when they supplied him with Kathy Mabbitt. He didn't have to pay for her either. But this brings up the final point, because Latah County would be saddled with the cost for new attorneys and any work done by the new attorneys, which means new legal experts, which means new legal defense investigators if anything came about. Well, that would give Judge Hippler, who would be the judge who would hear the post-conviction relief, because it is assigned to a district judge, and the district judge who originally ruled on the case would be the most likely candidate. So yes, the post-conviction relief would go directly to Judge Hippler 9 times out of 10. And Judge Hippler would already know that thanks to the reporting of these mainstream morons.
Is the majority of that money spent on his defense?
Yes, actually. So about $5.5 million was what the defense expenditures included. And we know that those are for the attorneys themselves, but also for all the expert witnesses and the investigators and all the work that was done as they were building toward trial, which obviously didn't happen. But
that the defense team had already been paid and spent $5.8 million in preparing for trial. The last thing that I think that Judge Hippler would want to do is appoint different attorneys when the attorneys that are already assigned to the case has already been paid and already done the work and are already prepared for trial. 5.8 million reasons for the judge, for the Hippler, to want Kohberger's current attorneys to stay on board. And that, I believe, has been the plan since the very beginning. In Idaho, once counsel is appointed, including multiple attorneys and a Pro Hoc Vice out-of-state counsel approved by the court, the appointment continues until the court terminates it or the matter concludes. The fact that the full team is still actively assigned 9 months after the plea indicates the trial court has not ended their representation. This is consistent with Idaho practice in complex or high-cost cases where the court sees value in continuity, especially when millions have already been invested and the record is extensive. Pro hoc vice admission is controlled by the court and can be maintained as long as the court permits it and local counsel requirements are satisfied. This ongoing assignment directly affects both the newly discovered evidence claim and the question of retaining the team for post-conviction relief. The results of the leak investigation can still support a newly discovered evidence claim under Idaho Code 194901. Because the team has remained actively assigned for 9 months, they've been in the best position to monitor the special prosecutor's work, any criminal investigation, and the production of new materials, findings, transcripts, immunity grants. This strengthens the due diligence element. The defense did not sit idle. The court itself kept the team in place. They could not have obtained the full investigation results earlier because the investigation was ongoing when the plea was entered and the continuance was denied. The new evidence, identity, and circumstance of the leak, any state involvement, effects on witnesses, remains newly discovered relative to the time of the plea. The team's continued assignment means they already have the institutional knowledge needed to quickly analyze and present this evidence in a PCR petition without starting from scratch. Retaining the same team. Now with the fact that they're still actively assigned, yes, it is strongly in both the defendants and the state's practical interest to continue with the same team. And the fact that they remain actively assigned 9 months later makes this the most logical and efficient path. The fact that the entire defense team, including the out-of-state pro hoc vice attorney, remains actively assigned and working 9 months after the plea deal that included a waiver of appeals can reasonably be viewed as consistent with the court anticipating ongoing or future post-conviction work related to the leak investigation. However, it does not conclusively prove that the continued assignment was specifically anticipated because of the leak investigation. It is strong circumstantial evidence of continuity planning, but other explanations are also possible under Idaho law. Connection to the leak investigation. In the scenario you described, several facts align with the possibility that the court anticipated post-conviction issues arising from the leak, i.e. the judge had already expressed strong concern about the leak of material under a non-dissemination order. The judge suspected state involvement, took the unusual step of appointing a prosecutor with subpoena power and the ability to grant immunity. The defense had specifically requested a continuance to wait for the investigation to finish and to learn the leaker's identity. The judge denied the continuance, but did not terminate the defense team's assignment. Keeping the same specialized team, including the pro hoc vice attorney, actively assigned for 9 months while a leak investigation and any follow-on criminal investigation proceeded, is consistent with the court wanting the team that already knew the protective order, the leak, the case record, to be available if new evidence emerged. This would position them to efficiently handle a post-conviction relief claim based on newly discovered evidence from the investigation under 1949-01 without the delay and cost of new counsel having to learn everything from scratch. In short, the continued active assignment is compatible with the court having anticipated that the leak investigation might generate material relevant to post-conviction relief.
Good evening. New at 5:30, a ruling after today's pretrial hearing in the case against Brian Kohberger. It comes after an episode of Dateline that aired previously undisclosed information in this case. In the ruling, Judge Stephen Hippler says the information must have come from someone currently or formerly involved in law enforcement or the prosecution of this case. He's ordering the prosecution to compile a complete list of everyone who has had access to the details of this case. A gag order was issued early on in the case against Brian Kohberger, the man accused of murdering 4 University of Idaho students in their off-campus home. That covers all members of law enforcement, the prosecution, those affiliated with this case, and even the victims' families. Judge Hippler says the leak could severely impact the ability to seat an impartial jury.
But we are dealing with some time-sensitive stuff right here because the actual sentencing was July 23rd, 2025. That started a bunch of clocks in this case. First of all, the first clock was an appeal window due to Garza v. Idaho of 42 days. So at the end of 42 days, since there was no appeal filed, then the 1-year post-conviction relief window started, and that's September 3rd, 2025. Here's where it gets interesting, though. The habeas corpus deadline is 1 year from July 23rd, 2025. It doesn't recognize the 42-day Garza appeal window in their deadline. However, you have to file for post-conviction relief and be denied before you can file habeas corpus. So if you file for post-conviction relief, it stops the deadline to file habeas corpus and does what's called tolling It tolls the deadline because you have to file the PCR and be denied before you can file the habeas petition. Here's where everything gets so confusing for everybody, and it's right for everybody to be confused. If you wait past the July 23rd, 2026 official deadline to file habeas corpus, to file post-conviction relief because you are afforded the extra 42-day window, then there is actually no time left for the tolling to accrue, which means if you wait until September 3rd and you're denied and you try to file habeas on that exact same day that you're denied, they will deny the habeas due to the expiration of the habeas time clock. I know that sounds confusing, but that seems to be the catch-22 in the way all of this works. They haven't thought it out, I guess. So I think it's very important to have at least a day or two left on the tolling for the post-conviction relief. I mean, for the habeas corpus if you're denied post-conviction relief. So that means that if a post-conviction relief filing by the Kohberger defense team doesn't happen prior to July 23rd, they effectively lose their ability to file habeas corpus federal petition once the PCR is denied. So we're on a 22-day clock for Kohberger to have any hope of filing for habeas corpus once the PCR petition is heard. There is still a 65-day clock, though, to file PCR. It's my understanding and my thoughts that they believe that the PCR will be accepted by Hippler because of everything I've talked about in this video, and they might not be worried too much about the habeas corpus federal petition. However, that would be, if it came back to bite them in the butt and Hippler denied the PCR, you would lose the federal habeas option. So I think the smartest thing to do would be to file the PCR prior to July 23rd, so it tolls you at least a couple of days on the habeas corpus petition once the PCR is heard, if that makes sense. We're looking at basically, y'all, two clocks right now. 22-day clock for post-conviction relief to be filed to keep the federal habeas corpus option. If it doesn't happen, then there's a 65-day clock left on PCR, and that option is gone. I think we should see something within the next 22 days on Kohberger actually filing, and that is my prediction. So let me know your thoughts. So I know that's a lot of information to dump on everybody, but let me just see if I can wrap it in a bow. The post-conviction relief needs to be filed prior to July 23rd to have days left that can be tolled for the habeas corpus petition. So let's say they file post-conviction relief on July 20th. Then that would toll 3 days on the habeas. If the post-conviction relief was denied, then that would leave Brian Kohberger 3 days at the end of that denial to file a habeas petition. So it'd be advantageous for him to file post-conviction relief before the habeas petition deadline is over. If it goes past that deadline, then all that's left is post-conviction relief. And I believe that as long as he files post-conviction relief, the judge will accept it because I believe that's been their plan all along. Every party that's involved in this thing, and they just hadn't told anybody because of so many things in this case are unprecedented. So we're going to see more unprecedented things coming here really soon. But at the end of that, when they do file, I believe they're going to file for newly discovered evidence. They're going to use the actual evidence from the leak investigation in their filing so that they can keep the current defense team with all of the current players. And that's why I say maybe I am wrong, and Turvey and Cy might be sacrificial lambs working in this greater good thing. Because when you look at the defense witness list that they were going to submit for trial, they had 2 experts on there for crime scene analysis, Turvey and Nodal. They had 2 experts on there for the CSLI, Cy and Slavinsky. So they could keep all their work product, all the work that's already been done, keep their experts, go into trial with the proper number of experts, and have the ability for 2 of them to go out on a limb and create issues so they wouldn't be used at trial, but create issues around this situation that could cause some things to happen to ensure it does go to trial. There's a lot of stuff going on in this thing. There's a lot of complexities. There's a lot of stuff. Now, those two guys may have bailed out and they're working for the state too, so you never know. But let me know your thoughts in the comments of this video. Please like and subscribe to this channel. Post your comments, thoughts, criticisms. Till next time, Pavarotti's out.